Court rise. Application and appeal in the matter of DSN and Blackpool Football Club Ltd.
Please, Your Ladyship and my Lords, in this appeal I appear on behalf of the appellant defendant with my learned friend Mr. Nicholas Futrell, my learned friends Mr. James Counsel of Queen's Counsel and Mr. Benjamin Bradley appear for the respondent claimant.
Yes, thank you.
My lady, I wonder if I could ask a favour. I understand the air conditioning is not functioning, and my learned friend and I will be adding to the hot air, no doubt, in this room. Could we remove at least some of our accoutrements?
Yes, of course. Can we stop at the wigs and the gowns?
Yes, we won't go any further than that. If we could do that, that would be... Thank you very much.
Yeah. If anybody feels overcome at all, given the difficulties with the air conditioning, please let me know and we'll have a quick break.
Thank you very much. Lady, listed as an application with appeal to follow. In fact, the application relates to an unagreed bundle, and I would propose to deal with it in this way, if I may. I've mentioned it to my learned friend. It comes in when I get to ground 4, which is a limitation ground, and I propose we would prefer to open the appeal without any reference to those documents at all on the other grounds, and with an overview of the case as a whole. And then when I get to that ground, perhaps we can then have a debate about whether the court should look at that unagreed material.
Well, that sounds sensible, Mr. Counsel. You agree with that,
yes. Lady, we appeal with the permission of Lady Justice Simler on 4 grounds. 4 were refused from Mr. Justice Griffiths' judgment. I hope that the court has both core bundle, supplementary bundle, transcript bundle. I've mentioned the unagreed documents, and 2 authorities bundles, which are divided into limitation and vicarious liability authorities. And the first 2 grounds relate to the grant of permission to proceed out of time under Section 33 of the Limitation Act in a case, a claim which was brought 22 years late. And the second 2 relate to the court's conclusions and findings on vicarious liability. But the points that arise under the limitation grounds need, we submit, to be understood in the context of the issues relating to vicarious liability, with an examination of the authorities, in particular 2 recent authorities, which actually post-date Mr. Justice Griffith's judgment. And in particular, the Barclays Bank case, which I will come back to, but where Lady Hale said the key will usually lie in understanding the details of the relationship. That's in relation to what we call vicarious liability stage 1. And at stage 2, Lord Phillips in the Christian Brothers case quotes Lord Millet in Lister, saying that it was critical that attention should be directed to the closeness of the connection between the employee's duties and his wrongdoing. And for those reasons, which I'll come back to those authorities, we say that the court needs to see what the evidence was in relation to both substantive issues and in relation to prejudice, which was our complaint about the permission to proceed with this claim out of time. The 2 decisions of the Supreme Court, of those 2 recent decisions of the Supreme Court post-dating this judgment, the Barclays Bank one is of particular importance, we submit, because it provides a significant corrective to what we say was had become, and indeed the Supreme Court said, had become an excessive widening of the scope of that residual class of cases described as the akin to employment cases. And it had moved away from the sort of case which was considered in a number of the authorities, such as the Christian Brothers case, where for technical reasons the abuser was not in an employment relationship, there was no contract of employment, but that to all intents and purposes that person was on the staff, part of the workforce, was delivering the services of the employer, in quotes. And it had moved away into an area where it seemed to be becoming understood that what used to be called the independent contractor exception wasn't what it was, and that it really didn't necessarily matter that you had the tortfeasor was operating a recognizably independent business if he could also be described as somehow integrated into and important to the business of the defendant. And so I will come back to that, but that it was an important corrective. And the other case decided at the same time last year was the Morrison Supermarket No. 2 case. Morrison Supermarket seemed to be dedicated to bringing cases that elucidate the law on vicarious liability. The second case was about releasing personal data. Not a sexual abuse case at all, but we say that in that case, the second stage, the close connection test, as it's called, has been explained as being much more restricted than some judges and commentators perhaps thought it had been. And the importance of focusing on the connection between the tort and the relationship was that it wasn't enough simply to say there was a purely temporal or spatial connection between, close spatial connection between the tort and the job for which the tortfeasor was employed. One had to focus very much on what tasks had been assigned to him. That was the close connection, and I will come back to those cases. And so for those reasons, we say that the first ground relating to limitation, which is that the judge's conclusion, we have to say, was perverse on the question of prejudice, a key consideration under the exercise of that discretion under Section 33, appears to have been explained because he thought that he was looking at a much simpler test in relation to vicarious liability. Because he says more than once there was no dispute about the primary facts. Well, as I'll come to it, there were very significant disputes about what we say are primary facts, which would form the prelude to any conclusion as to whether vicarious liability on either stage 1 or stage 2 was established. And we submit the judge may have taken a very different view if he'd seen those Supreme Court authorities. But first, I would like to start with the case we were required to meet. In the core bundle at page 125 is the amended particulars of claim. And we see right at the start, at paragraph 1, in the third line, abuse and assault by Mr. Frank Roper, a football scout working for the defendant during a football tour of New Zealand, to New Zealand when the claimant was aged 13. Working for is obviously in itself not a very precise expression, but as we shall see, there was no case pursued that he was in fact under a contract of employment with the club. It was always on the basis of the akin to employment category. And then we see in paragraph 15.2, yes, 15.2, which provides for particulars of vicarious liability. And this is picking up the point I've just made. If the defendant contends that Mr. Roper was not on the defendant's books as a paid employee, then its relationship with Mr. Roper was akin to employment because the defendant caused or permitted Mr. Roper to hold himself out as being a representative of the defendant club and derive benefit from that relationship by using Mr. Roper as a source of young footballing talent for the club. And so that's harking back to him being a scout, and we court will be familiar, having read the judgment, what is meant by that. It's not in fact a term of art, but it's used fairly obviously to mean someone who is looking out for talent. And they can, a scout of course, can come in various forms. This club had an employed scout, a chief scout, Mr. Jack Chapman, and he had an assistant, Mr. Hurst. but scouts can also be school teachers or coaches of junior football teams, or indeed anyone who has some knowledge of footballing and who can be used to look for talent.
Well, isn't the critical thing in that last sentence being used? Because
yes,
you don't submit that he wasn't a scout, in the sense that he was someone who, more than just waiting to see if someone turned up, would feed people towards Blackpool. Whether he would feed them elsewhere doesn't matter for this question. But
we have this, it may sound like a quibble, but what we say is actually the evidence showed that he was scouting for his own junior team. And the conclusion of the judge was that indirectly benefited Blackpool.
Okay.
So in fact...
That's what I wanted to clarify. Your position is he wasn't a scout for Blackpool. He was a scout for his junior team, which, as a matter of fact, happened to feed lots of people into Blackpool.
I mean, I have to accept that he was described as a scout for Blackpool by many witnesses, but what they actually meant by that wasn't entirely clear. But in the end, it seemed to be that he set up he had his own junior team, and then he would proffer the talented players. Now that may be using the word scout broadly another way of looking at it, but that would be like the PE teacher at a school who has a connection with a club. We have some evidence of such a case, and sends good players for trials. But going back to paragraph 6 of the amended particulars of claim, paragraph 6, when the claimant was aged 13, a trip was organised by Mr. Roper for the boys playing in the Blackpool School of Excellence to play football in New Zealand. Then there's a reference to the meeting for parents and boys attended by Mr. Roper. And further down, the end of that page, the trip was paid for by Mr. Roper, but was endorsed by the defendant. The son of Sam Ellis, its manager, was one of the boys who went, and members of the defendant's youth team accompanied the group to help out. Apart from the youth players who were aged between 17 and 19, Mr. Roper was the only adult on the trip, and the boys were in his charge on behalf of the defendant. And so that's a clear allegation of a trip organised for a section of Blackpool Football Club, the School of Excellence. I'll have to say a bit more about that in a moment. A trip organised by him, but for a section of Blackpool Football Club. And so on one view, this is a fairly straightforward allegation of, leave aside the description of him as a scout, of somebody, an adult, being put in charge of some boys from a football club, a junior part of a football club, who is the responsible adult sent on a trip. And that would be a very straightforward case for vicarious liability. However, things are not so simple, as we know, even just looking at the particulars of claim. First of all, it's pleaded in terms that it was organised by Mr. Roper. Secondly, it's pleaded in terms that he paid for it. And thirdly, as we'll see, it doesn't arise from the pleading, but as we shall see, Mr. Roper was running a junior club some 60 miles away in South Manchester. But in fact, the case which I've described as an apparently straightforward case on the pleadings turned out to be significantly contradicted in the evidence, either not supported or contradicted. At most supported only by impressions and understandings of some witnesses gathered from what Roper himself had said. When I come to vicarious liability, I make the submission that it cannot be fair, just and reasonable to impose vicarious liability on a body which has where the basis for doing so is entirely what has been said by the tortfeasor, rather than anything done by or represented by the defendant. Now, the Blackpool School of Excellence, some evidence about this, was not really a school at all. It was simply an opportunity for boys between the ages of 11 and 14 to attend for training sessions at the club's training ground in evenings after school on Tuesdays and Thursdays, with a bit extra in school holidays. There was no team for these boys. They remained playing for their own junior clubs or their own school teams, and they were obviously at school and living with their parents. At 14, they could be signed as associated schoolboys, but even then they would be, as the name implied, merely associated with the club. They would, again, continue at their schools and continue to play for local teams or local Sunday league clubs. Only at 16 would a contractual arrangement arise when they could sign as apprentices. Jack Chapman was generally responsible for the youth setup. There's no dispute about that. It was not suggested that Roper was involved in coaching boys at Blackpool Football Club. To the contrary, the evidence was that he did not do that. He coached his own junior team boys. He was a businessman who lived in Stockport. He ran during the material time, at any rate the time leading up to this event, a junior team called Nova Juniors in South Manchester, as I've said, some 60 miles away. There is mention, a passing mention in a paragraph, in a later paragraph of the amended particulars of claim, to a Nova, paragraph 13, but this was after the New Zealand tour when the assault occurred. Mr. Roper set up another team called Nova. The claimant declined to join this team. And in fact, the claimant was never part of Nova Juniors, the new one or the old one. There was plenty of evidence that Roper was a keen supporter of Blackpool Football Club. He was well known there. He also had a sports shop, at any rate in this period, in Blackpool, which was not. It was made clear that was not anything to do with Blackpool Football Club. It was his own business, and that he had referred a number of players from his Nova Juniors South Manchester team, including two at least, who went on to have stellar careers, Paul Stewart and David Bardsley. It was also apparent from the evidence that Roper had organised and paid for some 8 or 9 trips abroad, including trips to America, which it was never suggested had anything to do with Blackpool Football Club. So that sets the scene on the what were essentially uncontroversial matters. Unfortunately, we submit that there were significant omissions in the judgment, which means that we cannot avoid inviting the court to look at the evidence that was there, including the witness statements and the transcript, to identify changes or qualifications made in the oral evidence, which ought to have been mentioned, but which was not, and which we say provides the starting point for the 4 grounds of appeal that this court is considering. As far as the trip was concerned, the evidence was that the cost of doing so, which came out of Mr. Roper's own pocket, ranged between about £22,000 and £35,000, the latter depending on the exchange rate with New Zealand dollars. And bear in mind, this was 34 years ago, so a substantial outlay by him. That in itself, we submit, completely contradicts the case that this was a Blackpool Football Club trip. What employee or person in a relationship akin to employment would be required or expected not just to organise a trip abroad, but to pay for it out of his own pocket? The judge seized on some evidence proffered by one of the defendant's witnesses that he had a memory of a donation of £500 being made by the club towards one of the trips. They couldn't remember which one. The judge said he thought it was probably this trip. But on any view, that was a mere token in the context of the overall cost. In addition, and this is important, it is clear that notwithstanding what is said in the amended particulars of claim, paragraph 6, that this was a trip organised by Mr. Roper for the boys playing in the Blackpool School of Excellence. On the evidence, one could only confidently say that there was one person who was attending the Blackpool School of Excellence, namely DSN, the claimant himself. There was another boy who was an associated schoolboy, and there were some apprentices helping out older boys from the school. There was another boy where the evidence was equivocal, and I'll come back to that. And what the claimant said in his witness statement, which is in the supplementary bundle, starts at page 9, I think. And he explained what was happening. We're talking about an event in June 1987. And in paragraph 7, he says in the second sentence, I was the YMCA Football Club captain for 6 years. I played for the under-9s team right through to the under-16s. This team was based in Lytham.
Forgive me, where are you?
Paragraph 7 of DSN's
Witness statement.
Witness statement, page 9 in supplementary.
Thank
you. So he's describing the teams he was playing at YMCA Football Club based in Lytham. Right through, this covers really the whole of this period because he was 13 at the time. I also played for the Blackpool representative side, under-16s, and it was explained that's nothing to do with Blackpool Football Club, that's the geographical Blackpool. Lancashire Boys Clubs and England Boys Club trialist. His Blackpool representative side was the league I played in, and this was part of the Blackpool and Fylde League. It's a matter of geography, but Blackpool is part of the Fylde Coast, in the middle of the Fylde Coast, and therefore this league, geographically, is either side, as I understand it, of the town of Blackpool, which is where Blackpool Football Club, of course, is based. Paragraph 9, he says that he was, second sentence, Roper was a well-known football scout and scouted me to play for the Blackpool School of Excellence, run by Jackie Chapman, the head coach, and Sam Ellis, the manager of Blackpool Football Club at the time. Roper would attend some coaching sessions, would interject at times and have some input into the training sessions. I'll come back to that, but this of course, is 2 years, age 11, 2 years before the events we are concerned with. In paragraph 10, 4 lines down, he says a number of players I played with at the Blackpool School of Excellence went on to play football professionally. Alan Wright, Jamie Forrester, Kevin Sharp, all went on to become professional footballers. From memory, I didn't have a trial, and Roper contacted my coach at the YMCA Football Club, Lyndon Moore. I expect that Roper was then put in contact with my parents. My mother and stepfather attended every game I played. I think they would have spoken to Roper at one of the games. Roper was essentially able to offer a place at the School of Excellence. We'll see in a moment that actually Jamie Forrester, Kevin Sharp were not attending the School of Excellence or that they had anything to do with Blackpool Football Club. And then at 12, he says for 2 years he attended the School of Excellence, and with Jack Chapman doing the coaching. He says he trained for as much as 7 nights a week for the teams, plural, for which I played. My parents would drive me to training. We would often give a lift to Tim Ellis, Sam Ellis' son as well. The suggestion was that that was a lift to the Blackpool School of Excellence, but as we shall see, Mr. Ellis doesn't remember his son attending that. He did certainly attend the YMCA club, and therefore, because he's talking about the 7 nights a week of training, only 2 of which would have been at the School of Excellence, that lift to Tim Ellis, of course, could be to other sessions. He then talks about his impression in paragraph 13 that Roper was influential at Blackpool. So then we come to paragraph 20, the New Zealand trip. And he says, when I was 13 years old, Roper organised a trip to New Zealand for the boys playing in the Blackpool School of Excellence as an opportunity to go and play football with other teams in New Zealand. Now, that is quoted 3 times by the judge, paragraphs 71, 126 and 165 without comment or qualification. As we shall see, it was heavily qualified in his oral evidence. At paragraph 21, he says that, third line, he recalls his parents had concerns as to why Roper was funding the trip, what was in it for him. And in 22, he says there were about 20 boys who went on the trip. They went to New Zealand, was known as a Blackpool representative side from England. This was how we referred to ourselves. Note, he doesn't say Blackpool Football Club representative side, and we know from his earlier paragraph that there was something called a Blackpool representative side, which was the league he played for in the Blackpool and Fylde League.
Is that common ground that when he's talking about playing for the Blackpool side,
well,
in that earlier context,
he was
he's talking about a representative side for the city, as it were, or the area?
Yes, when we come to the transcript, what he said in cross-examination, I think it is clear enough. Whether it's common ground, I'm not entirely sure, but I will have to come to what he said about that in a moment. But it's certainly, when you read that with his earlier reference to the Blackpool representative side, that doesn't seem, on the face of it, to be a Blackpool Football Club representative side. And then it's I think the next only further paragraph to refer to. Yes, paragraph 38, page 17. After we returned to England, so this is after the assault has occurred. Roper sent up another team called Nova Juniors, and he asked me to join the team, but I refused. But much of that came to be qualified and modified in oral evidence, and if I could take the court to the transcript bundle, please.
Can I just raise one thing now?
Yes.
Because I'm bound to forget it. Was any football played in Thailand?
No, none at all. And that's an important point. It was never suggested it was. And I will come to what the Thailand trip. It was either a holiday for the boys, or it was a. Well, we say it was a.
You say it was using the boys as mules to bring in counterfeit goods, but I just wonder whether it was.
No, I don't think it was said. They went to Bangkok and Pattaya, I think, but I don't think it was said they played in matches. Thank you. Page 6 of the transcript bundle. At letter C. And this is just to establish the point about the training. And this is my then friend in chief, asking questions in chief. It was a distinction between the School of Excellence and the other clubs that I played for. I would play up to 7 nights a week. Right.
Sorry, can you give me that?
Page 6, letter C. Lady.
So, not internal page 6.
Oh, sorry, yes. I hope the court has bottom right larger numbering.
Yes, when you refer to the number, it's bottom right.
Yes, I'm sorry, I should have said that.
So, paragraph C. Yes, got it, thank you.
So this is explaining he would train for 7 nights a week, but it was School of Excellence probably between 1 and 3 times per week. But they played elsewhere, so he's playing every night. Mainly evenings, occasional training at weekends. Then at page 11, at the top of the page, cross-examination, so he's answering a question. It was my understanding, this is being asked about being offered a place at the School of Excellence by Roper. Well, my understanding, he would have spoken to my parents. He didn't directly offer me a place at that time, which is why I assume there was a dialogue with my parents, because I then attended the School of Excellence. Question. So it was not, as you understand, it was not necessary for anyone such as Mr. Chapman, the youth coach at Blackpool, to make a decision whether to offer a place. It was Roper's decision. Having not been directly involved in that dialogue, I would not know. No. And further down, letter C, he ran a club called Nova Juniors in South Manchester. Did you ever go to where he ran that club? No. Page 13, letter C, he's asked about a police interview that he was conducted in December 2016, and the relevant paragraph is quoted in the letter E. where he said he was scouted to play at the Blackpool School of Excellence. He was playing for his local YMCA team, and either Jackie Chapman or Frank Roper had come to scout him. So it was put to him, well, it's the word either or. And it was put that there seemed to be some doubt as to who was the person who recruited you for the Blackpool School of Excellence. The court will bear in mind that this is Mr. Roper, based in Stockport, apparently scouting someone directly for the Blackpool School of Excellence, right up in the Blackpool area, the filed area. And then he says at H, I think this transcript is part of a wider interview, I think both are relevant. Well, you don't have anything more than this. Yes, I can only rely on what is there, absolutely. Have you any reason to think the police officers got it wrong? No. The judge, nevertheless, found in the absence of Mr. Chapman, who would have been the person we say who would decide whether to recruit boys from the File Coast or Mr. Hurst, that it was, in fact, Roper who recruited him.
And do you say that finding simply wasn't open to him on the evidence?
It's actually a finding that... Now, I couldn't say that if we weren't dealing with limitation, but it has a bearing on the limitation prejudice point, because it's an aspect of the case in which the learned judge is making findings, and we say in our skeleton argument, putting the cart before the horse when he's coming to consider the Section 33 discretion. That's our ground 4. And then we have at page 28, still being cross-examined at letter just below letter A. Then you say an area representative side, Blackpool touring Thailand, Australia and New Zealand. I should explain that he was being asked, and this is apparent from letter E on the previous page, about a document he wrote in 1992 when he was at university. It seemed to be some summary of his sporting history, I think. And he said, then you say an area representative side, Blackpool touring Thailand, Australia and New Zealand. Is that the trip we're going to be that you mentioned? No, that was the only trip I went on. That was the only one, yes. Question, represented Lancaster Boys Club. That's a later reference. So he's also, again, in that document referring to, which was way back in 1992, referring to a Blackpool representative side. And then at page 32, I'm below letter E. What I'm going to put to you, I'll take you to some references, that in fact it was arranged for a number of schools and clubs around the File Coast and the Blackpool area, not for the Blackpool School of Excellence. That's a reference to the trip to New Zealand. In fact, we see it above the page. I take him to paragraph 20, which I've referred to, that it was organised for the boys playing the Blackpool School of Excellence. And he says at letter F, from my perspective, it felt like it was being arranged through the Blackpool School of Excellence. Yes. And he gives, and then we've already heard him say he had no dealings with the South Manchester Nova Juniors. That's top of page 33. Then he then describes who went on the tour, and at letter F he refers to remembering Jamie Forrester and Tony Green. And at letter A on the next page, did any of them play for Blackpool? We've mentioned Tony Green. Answer, his father played for Blackpool, right. Answer, I don't believe he did. So that would be Green. I think it was a father and son, both called Tony Green. And then below letter C, and I take him to a witness statement of Mr. Frank Sharp, whose son went on the New Zealand trip. Yes, but seeing what Mr. Sharp says, would it not be right to say that it seems to be a team that he's recruiting from the Blackpool area geographically, rather than from the School of Excellence? Answer, I wouldn't know, because I wasn't in that year group, whether they were part of the School of Excellence or not, because I was in a very different year group. Now, that's not mentioned by the judge. And as I've said, on 3 occasions, he simply repeats what is in that paragraph 20 of the witness statement. He then identifies various people in a photograph, and I'll come back to that. And at 37, at 37, 36, letter F, he confirmed that Tim Ellis was playing for the YMCA, and he was another boy who went on the New Zealand trip. And he says, so 4 or 5. Now that means there are 4 or 5 boys from the YMCA. So he identifies a number of people from the YMCA club he was playing with, and some other people. And he says at page 37, letter E, he's asked about a photograph, which I will come to in a moment. And he says, what are the shirts, the strip you are wearing? We are wearing, there is Everton away kit at the time. Do you know why you were wearing that? I believe because Everton were on a tour of New Zealand at the time as we arrived. So it was in keeping with the promotional aspects of what we were doing, because Everton Football Club were on a tour there. I believe they were champions, league champions. Who supplied that kit? Roper. And then over the page he says, we wore the England white kit at times as well. Right, anything else? No, apart from the training kits and stuff like that. One of the points we relied upon was that despite the fact that there was evidence that when boys went for trials at Blackpool Football Club, School of Excellence, they will be supplied with Blackpool kit, which was a tangerine shirt. And there was also evidence that Roper, who had a huge supply operation supplying football replica shirts, would himself supply Blackpool tangerine shirts amongst many other clubs' kit from time to time, and yet significantly not for this trip. This is, I'll come back to that issue. But the question is, if there were only, well, I'll come to how many, but I'm going to submit there was only 1, possibly 2 from the Blackpool School of Excellence on this trip. He said 20 boys went on the trip. Now we will see from what the witness that he called, who was the only one of two who were parents or adults at the time, Mr. Frank Sharp, whose son Kevin went on the trip, and Mr. Sam Ellis, who was the manager of Blackpool, whose son Tim went on the trip. They made it clear, or the evidence makes it clear, it was not a Blackpool Football Club trip at all. Of course, Jack Chapman would have been the best person to ask, but in the absence of him, the court had Mr. Sharp and Mr. Ellis. Mr. Sharp, his witness statement, the learned judge paid tribute to Mr. Sharp and said he was a witness he could rely upon, and I couldn't complain about that. That's the judge's impression of a witness. But what we say is that Mr. Sharp didn't in fact prove what the claimant set out to prove, quite the opposite. His witness statement is at supplementary bundle, page 36. And in paragraph 2, he says he first met Frank Roper when he was managing an under-13s team in Blackpool, Poulton Youth.
Hold on a second. You're ahead of me, Mr. Kemp.
Page 36.
Supplementary bundle 36 is the start.
Start of Frank Sharp.
And you are where?
Paragraph 2.
Good start, thank you.
So he describes managing. He's managing an under-13s team in Blackpool called Poulton Youth. During a game in early 1987, in fact, in chief, he corrected that to 1986. Roper approached me on the touchline with 2 men that I know to be scouts from Blackpool Football Club, Jack Chapman and Bill Hurst. Due to the fact Roper was with Chapman and Hurst, who I knew to be Blackpool Football Club youth coaches, my impression was that Frank Roper was also associated with work for Blackpool Football Club. Paragraph 4, he describes the tour to New Zealand. Roper told me he was interested in taking a select team of boys from the Fylde area to New Zealand for a football tour in May 1987. So that's what he recalls, a select team of boys from the Fylde area. Roper told me he wanted 4 players from Poulton Youth to be included in the squad. Jamie Forrester, Anthony Green, Terry Barnes and my son Kevin Sharp. So he's identified 4 players. I asked what the cost would be, told me no cost. He says it set alarm bells ringing. He said, when he spoke to the boys' parents, they asked a lot of questions about Roper. I was unable to answer them. This is paragraph 5. So he phones Tony Green, who he knew, because Tony Green had been a professional football player at, this is the father, at Blackpool Football Club. And I told him that he had 2 scouts with him, Bill Hurst and Jack Chapman. Tony Green said he would contact Sam Ellis, who was the first team manager. Then he rings back. Tony Green informed me that Sam Ellis' son, Tim Ellis, was also in on the trip. In my mind, this made the trip legitimate and reassured me that the trip was endorsed by Blackpool Football Club. Well, bit of a non sequitur there, but that's what he's saying. But so far, we've got a description of a man, a complete stranger, who turns up, he's a bit suspicious of, he's going to pay for a trip, but he wants 4 players from the Poulton youth team to go on this trip. And all he's established so far is that Sam Ellis, who happens to be the manager of Blackpool, his son is going. Then he refers to meetings arranged at the Tangerine Club. Now, this is a building, he says, closely affiliated. I think it was owned by Blackpool Football Club. Paragraph 7, Sam Ellis attended the meetings, various other people. Then he says in the second paragraph, I understood that all of the players going on the trip were from teams in the Filed Youth Alliance League. Remember speaking to Sam Ellis and his wife about the trip. So again, it's the Filed Youth Alliance League are the source material, as it were, for the players. And then he says at the end of paragraph 8, they were going to stay in a hotel in Bangkok. Roper was paying for all of this out of his own pocket, as the parents of the boys were not paying for the hotel stays. And 9 apprentices at Blackpool Football Club also attended at the meetings. I got a chance to ask them about Roper, and they said he was sound and not to worry. I specifically remember speaking to Simon Rooney, Mark Bradshaw. I hesitated there because some of these names have to be anonymised, but I don't think those two do.
Do we need to do anything about that publicly, Mr. West?
Yes.
There's no member of the press here that I can see, but...
Being live streamed, that's the only problem.
Yes.
Well, I mean, there is an order out there.
There is, but I
but
don't know if that was made clear at the start of the recording.
No, I don't know.
For the avoidance of doubt, there is an anonymity order made in respect of certain individuals who were victims of sexual abuse, and it is a contempt of court for anyone to publish any detail that could lead to the identification of any of those people. I know that you'll refer to them by initials, but sometimes as a slip.
Yes, in fact, I think all these names, well, some of them were witnesses. Bradshaw wasn't. He was happy for his name to be mentioned.
Yes, yes.
There was no problem there.
Yeah, I mean, if it helps, I think I'm right in saying that the exercise has been done. Where in the transcripts there are names, they've been
removed.
So I think we can be quite confident.
Yes.
Once
I was
these
just
names appear or not.
Well, since both of you are immersed in it, as I say, it's very natural sometimes for a name to slip out. And so, if there's any doubt, I would much prefer a journalist to get in touch with the court to make sure that the anonymity order does or does not apply.
Really, I'm grateful. And then he mentions those apprentices, the names of 2 apprentices going, and also the associated schoolboy, whose name is at the end of paragraph 9. Then he says at paragraph, the impression I had from attending the meetings was that the parents were looking to Blackpool Football Club for reassurance about Roper and wanted to ensure that the trip was supported and endorsed by them. Roper seemed to know everyone affiliated with the club. Roper had previously set up a team called Nova Juniors in the Manchester area and bragged about having introduced, then 3 names are mentioned. 4 names, sorry, as well as the existing apprentices. I believe Roper said this to highlight his connection with the Blackpool Football Club. So again, we have something emanating from Roper himself and an impression which forms on the mind of Mr. Sharp. Then 11, knowing that Ellis's son would be going on the trip meant I was satisfied it was legitimate, and I believed that Roper was a recruitment agent or scout for Blackpool Football Club. He gives what he understood to be the cost of the trip in paragraph 12, 22,000 to 26,000, a huge amount of money in those days. And then 13, I spoke to other parents about the trip, and we settled on the purpose of the trip, being that Roper had organised the trip with a view to the boys going on to sign for Blackpool. He says he doesn't know if any payments were made to Roper for this, but I assumed there would be. I couldn't see any other way he could recover the huge outlay. What's curious about that is although it may be understandable because this is using hindsight, is of course he doesn't say anywhere that he asked the obvious question of anyone at Blackpool: is this a Blackpool Football Club trip? It's all about impressions and understandings and the parents settling, as he put it, on what the purpose was. And of course, to be fair to Mr. Sharp, and indeed anyone else, any of the other parents, they wanted to know who Roper was, and the boys, including the apprentices, were saying he's sound, he's all right. I suspect these days parents might be a little bit more sceptical, but that is clearly what he is saying. Now we say that evidence, even before we get to what Mr. Sharp said in cross-examination, does not amount to a case that this was represented by the club, by anyone at the club, to be a Blackpool Football Club trip. And what then we see from the oral evidence, a little bit more detail. Paragraph, transcript page 73, please. Sharp cross-examined. Letter E, just establishing the filed case, Blackpool as part of the filed case. Letter G, page 73. Letter G, did your team have any relationship with Blackpool Football Club? No, nor with any other club. Over the page, letter E, asking about the Hurst and Chapman attending, as he said, with Roper. He said, in my opinion, they were there to give credibility to Frank Roper. When Frank Roper initially approached me on the touchline, he was interested in taking four of my boys, all members to New Zealand. To be perfectly honest, he didn't represent himself as being from Blackpool Football Club. So even Roper himself wasn't saying at that point he was from the club. And at the bottom of the page, because there was a game in progress, the conversation was just a few sentences. He was said he was interested in taking a select team of boys to New Zealand in the summer, and 4 of your boys I'd be interested in taking. He knew the boys. That's how much it would cost. He also says this, which is maybe of some relevance, at the foot of page 75. The middle of paragraph, page 75, below letter C. There's some evidence that Frank Chapman, should be Jack Chapman. Jack Chapman left Blackpool Football Club and went to work for Roper at his sports shop. Answer: later I can verify he did work in the shop. You knew that? I knew that, yeah. Roughly what period are you talking about? Well, I mean the period over a 2-year period, so I can't be specific. It would be in probably 87. And then letter F. Can I also say that some of the Blackpool apprentices also helped out and worked in the shop? And he gives a letter G 3 names, including 2 we've already seen, who went on the trip. And he said he saw them in there. And then over the page at the top, but it was not a Blackpool Football Club shop in any sense, was it? No, it wasn't. No. So we now established that the evidence of Mr. Sharp is that Roper was recruiting from the filed case local teams that had nothing to do with Blackpool Football Club. That at least 2 of the apprentices who went on the trip worked for Roper in his shop, and indeed Jack Chapman at this time appeared to be working for Roper in his shop, which was nothing to do with Blackpool Football Club. And then at page 77, at letter B, having confirmed, being asked about whether he'd heard the name Nova Juniors, he says, well, I'd heard as the meetings developed for the tour to New Zealand, I got an opportunity to speak to boys who were apprentices at Blackpool Football Club, who'd been on trips to New Zealand with Frank Roper as members of Nova Juniors. I emphasise that. So as time went on, I got more aware of Nova Juniors, but initially I'd never heard of them. And he refers to the possibility of America being mentioned. And at letter F, your son Kevin, was he then connected with Blackpool Football Club in any way? No. Was he ever connected with Blackpool Football Club? No. So that directly contradicts what the claimant said in paragraph 10 of his witness statement. And I think, moving hastily on, we have more evidence. Page 81, describing this, why he had an impression that Roper was associated with Blackpool Football Club, top of the page. No, I wouldn't say that. I had no doubt he had an association with Blackpool Football Club, because why would he have companions who were both Blackpool Scouts in his initial visit, his initial introduction? Question, they might just be friends, might have been friends of his, they might have been, and you knew Chapman. I knew Chapman, I knew Hurst as Blackpool Scouts. Way of gaining an introduction. Give himself credibility, yes. Otherwise he might just be a complete stranger. And he confirms at letter G that he was seeking to team of boys from the filed area. He also confirms that the Tangerine Club was a convenient central venue for parents from that area to meet. That's the foot of the page going over to the top of the next page. And it's of some interest that at the foot of that, page 82, that Tony Green hadn't heard of Roper either. Tony Green, who had been a professional at Blackpool Football Club himself. Absolutely, he hadn't heard of him. And then we have Mr. Ellis, an important witness, who was called by the claimant, and he was the manager of the club, manager of the first team, but generally spoken of as the manager of the Blackpool Football Club from 1982, I think until 1989, so covering this period. His witness statement is in the supplementary bundle at page 112. And I will have to come back to that for other purposes, but the only reference he makes to the New Zealand trip is in paragraph 12, which is page 112 of the supplementary bundle. He says, I also can't remember when exactly it was his involvement with the club ceased, this is Roper, but I do know that he was still around in 85, 86. As he arranged some trips to the Far East and to New Zealand that my late son, Tim, went on. Probably still around in 1987, I can't remember for certain. So there's a passing reference to that, but not anything more which assists the claimant's case to the effect that this was a Blackpool Football Club trip. And in fact, when in oral evidence, it becomes clear that it was not. Transcript bundle, page 160. Mr. Ellis being cross-examined.
Okay. 116.
160.
Thank you.
Letter G, right, and he says, Frank Roper did the Manchester area, and Jack and whoever he had doing it with him scoured the local area. So this is a reference to Roper as a scout, whatever that means, but we'll come back to that. And he makes it clear that it was Roper was Manchester, and Jack and anyone else with it was local. So that's a bit of an oddity. Why is Frank Roper recruiting the claimant in 1985 in the filed area? But there it is. He says at the top of the page he would put him forward to Jack. Jack would go and watch him, and I would be out of that equation, that Jack would have the authority to sign them or not to sign them. At page 163, letter D, he's being asked about Nova Juniors being in the Blackpool area. Sorry, letter E, I should say. And yeah, he's being asked about Nova Juniors. He says at letter E, I would expect if they played for Blackpool, they were playing in Blackpool colours. And then at letter G, he's asked about the New Zealand trip that his late son Tim, went on. I should have referred to 162, the foot of that page. Mr. Chapman is obviously the man who would decide whether to sign a youth player as an associated schoolboy. He would have full authority to do that. And then at the top of the page, and when the School of Excellence was created, which was during your time, do you remember that? I don't think we still had the same people, we still had the same organisation, we had it all the way along. So in disguise, probably. I don't remember it being called the School of Excellence while I was there. Then at page 164, asking about the New Zealand trip. His son went twice. Roper was funding the trips. He had a business, yes. Letter C, I knew he brought gear back from these trips. I think they stopped off in Thailand on the way back and he had some contacts there where he got his produce, his goods. Do you remember how Tim had been spotted as a possible candidate for that tour? Where was he playing? He was playing for the YMCA in St Anne's. Right. Did he, as far as you remember, ever play for Nova Juniors? No. Did he have anything to do with Blackpool Football Club, apart from having a father who was its first team manager? No. I can tell you, Frank Roper said to me that he thought Tim had the ability, and Jack Chapman said he didn't. Then letter F, so he never had any connection, no, with Blackpool Football Club. Not with the School of Excellence or anything like that? No, he may have gone at night, but I didn't remember him doing that. At page 166, he's asked about meetings at the Tangerine Club, letter C, which belonged to the football club. And he says at the below letter E, I took one of the meetings because some of the parents came in concerned about the trip, how it was, what it was. And I said to them I was quite happy with it. My own son was going. Yes. That would have endorsed the trip and probably got other people to let their kids go as well. And do you remember why the Tangerine Club was used? Was it just a convenient location? It was the best location. It was central for local people there, probably the only place that would have us. We were told that 20 boys went, quite a lot of parents, yes, letter B on the next page. But was it in any sense a Blackpool Football Club meeting? No, it was, I went as a father. More likely that the people took, I understand, advice from what I said. And so that, of course, was the obvious opportunity, if that had been Mr. Ellis's recollection, for him to say, oh, not only did I say my son is going, but this has the imprimatur of Blackpool Football Club. It's a trip for our School of Excellence boys. And he doesn't say that. His own son, he doesn't even remember having anything to do with the School of Excellence. We then have re-examination. It says cross-examined by Mr. Counsel, but he wouldn't have done that. Re-examination. And at page 169, foot of 168, letter G, so far as Blackpool's involvement in that trip was concerned, you've told us the meeting was at the Tangerine Club. Yeah. Did it have any other involvement in the proposed trip? What, the football club? Yes. Not that I know, really. All right. Not that I know. So the state of the evidence, contrary to what had been in the pleaded case and the claimant's witness statement, was that the adults who were adults at the time, the only two parents who gave evidence, were clear enough that whatever may have been thought about an endorsement by the manager of Blackpool Football Club, it wasn't a Blackpool Football Club trip, and it wasn't for the School of Excellence. Now, in the supplementary bundle, there is a photograph at page 150, but it's not very distinct. And I put on the bench, I hope you have it, a colour photograph, a colour version of this photograph, which was taken in New Zealand and was one of the documents the claimant kept and was able to disclose in these proceedings.
SB 150.
It's 151, in fact, this photograph. It's rather small, I think.
Yep.
And the other point about the document I had put on the bench was that this was actually put in closing submissions to the judge because it has a legend attached to it, which is derived from the evidence. So we see from it what, after a fairly laborious exercise of asking questions, we established, so far as it was possible, were the names of the individuals involved, and again, so far as possible, what clubs they played for. And we see, yes. Yes, well, there's time. Thank you. Yes. The document may have some names that should have been anonymised. Roper himself is there. In the back row, four apprentices who were apprentices at Blackpool Football Club. Two have been mentioned already. The first two names. There was evidence about these.
Subject to anonymity, are these identities agreed?
Yes. What happened was that
Could we be provided with a piece of paper which gives us, as it were, a legend?
Well, this provides it, but there was a fairly elaborate dramatis personae.
I think my lord has got the wrong photograph. This
Ah.
was put on the bench today.
Yes, I'm sorry.
Oh, right. So
With the
sorry.
legend.
So sorry,
Yes.
I didn't see it.
Thank you. So, although it was prepared by the instructing solicitor,
Thank you very much.
it was derived from. So, some of these names perhaps should have been. So, back row, four apprentices, two whose names we've already seen. Well, I won't mention the names. There are some, and then there's a lady on the right. She's not mentioned here, but she was Jean Robinson, who was, as it were, hosting the trip in New Zealand. And then we have a number of individuals. Poulton, you see, one sees a middle row. Two of them, Poulton. We've seen one of those. Two of those names have already been mentioned by Mr. Sharp and also by the claimant. That's their club, Poulton. Someone else, club unknown. Someone else, club unknown. Mr. Ellis's son, YMCA. An unknown individual. Someone whose name probably shouldn't have been printed, but he was the one who was a Blackpool Football Club associated schoolboy and had previously been a Nova Juniors Manchester player. Mr. Sharp's son, Poulton, an unknown. Someone else, club unknown. Oh, Jean Robinson, yes, she's mentioned. And then front row, we have a YMCA person. He was mentioned by the claimant, unknown. The next person was also mentioned by the claimant and also by Frank Sharp, Poulton, unknown. The next name was mentioned by the claimant in his evidence, YMCA. Then the next name is the claimant himself, and of course it shouldn't have been put in full, and he is YMCA, unknown, and Warren ? And if one goes back to the evidence we've had, what we know, therefore, is that the four apprentices had all, in fact, been on trips, but been players at Nova Juniors South Manchester, and had been on trips with Roper anyway, in that capacity. They were, two of them were also helping out Roper in his shop in Blackpool. And one of them, actually, and this is the third name, the evidence was that Mr. Roper lived with his parents. And had done for some time before this event. So there was a connection there as well. And we can see from the references, page 133 of the transcript. A witness called CFS confirmed that. And the other point that arises, you've already seen the reference to Everton strip. No dispute that what one sees is the team wearing the Everton, I think, away kit of that year, possibly the year before. There is not a single sign of any Blackpool Football Club tangerine or any other insignia.
I may still be confused. In which case, please forgive me. The information on this legend is agreed, is it?
Well, I say it's agreed. There was an agreed dramatis personae. We took names that were relevant to this photograph, and I think it is.
And you've concentrated on the clubs for which they played.
Yes.
And there is a reference in relation to one or two of them, BFC, Associated Schoolboy.
Yes.
What about association with the BSE, the Blackpool School of Excellence?
Well, I should have said that we didn't. That's not on the legend. But the only evidence was the claimant himself. He was undoubtedly there for 2 years. In fact, he produced a document. He had kept a registration form, which you have to fill in, showed he was entered into the Blackpool School of Excellence. And as I've said, he thought that others were, but when one looks at his evidence, beyond his parents driving Mr. Ellis's son, but that could equally have been to YMCA games. Mr. Ellis, not even having heard, he's a manager, couldn't even remember the School of Excellence, and saying his son had nothing to do with Blackpool. What we say, and I said this at the outset, is at the end of the day, notwithstanding the pleading, the most you have is one person from the School of Excellence on this trip, namely the claimant himself, possibly two, and the associated schoolboy is a Blackpool player, or he's associated, but he was also Nova Juniors.
You deal with this point in your skeleton about one or possibly two being there.
Yeah.
I can't remember. Do you provide references in your skeleton to the evidence on which you rely for saying that others were not BSE people?
I don't think we did because we didn't have the transcript, so we wouldn't have had the...
And again, this may just be my confusion. BSE itself did not run a football team.
SOE, School of Excellence. I'm sorry, BF.
The Blackpool School of Excellence,
yes,
did not itself run a football team.
Yes, the evidence was I can show the evidence of Mr. Hurst.
People would go and train there.
Well, they would go for 2 nights a week and possibly weekends, possibly school holidays. It was a way of introducing them to the club as schoolboys, only aged 11 to 14. The FA had a rule that you couldn't assign anyone, even as an associate.
I understand that, but they wouldn't have prevented someone running a football team.
No, but
they didn't.
But they didn't, and they were all playing, as we see, for their local teams. So the pleading case just falls apart, we say. And why on earth are they wearing another league club's kit? Claimant's evidence doesn't really explain it at all. Bearing in mind that Mr. Roper had access to all sorts of kit, and he could easily have provided it, even if the club didn't. The club could have provided it. And in fact, again, references at 134 of the transcript, CFS said that Roper would provide Blackpool kit from his supplies as well as kits from other clubs, Aston Villa and so on. They would change from time to time at Nova Juniors. So we have 4 from Poulton Youth, 4 I think from YMCA. As I've said, 1 at most who happened, and we say this was entirely incidental, happened to be attending the School of Excellence, done a couple of nights a week. And then of the and there are 18 boys, apart from the apprentices, in that photograph. Mr. Sharp had said his son Kevin was not at the School of Excellence. Mr. Ellis was doubtful about it. Nothing to do with the club. Records have been destroyed, of course, which would have made the position immediately clear. We have the claimant's own registration document. There would have been other registration documents establishing whether or not any of these individuals were entered into the School of Excellence.
Records destroyed in the 1990s.
Yes.
Before expiry of the primary limitation.
Yes, but as we say, the Donovan point says, well, if it's prejudice, it's prejudice. You go right back to the beginning, unless you're destroying documents when you know a claim is coming. Then that doesn't answer the point. So we then have a couple of other documents which are of interest. There's in page 149 of this documentary bundle, not very clear. There is a British Airways travel centre receipt, which the claimant disclosed. Right at the top of the page, it says passenger itinerary for Mr. Frank Roper's football tour. One might have expected if Blackpool Football Club wanted to make it a promotional tour that they might have asked Roper, if he was paying for it himself, to make that clear. But over the page, a document from a New Zealand newspaper, the New Zealand Herald, which is not very distinct. We did transcribe it, I hope accurately, in paragraph 94 of our skeleton argument. But it makes no express reference to Blackpool Football Club. And it refers to, in the second paragraph, Frank Roper and his squad of youngsters from Blackpool, England. Then the next one paragraph, most are 13-year-olds with a couple of 12-year-olds and a couple of older boys making up the group, who were chosen by Roper from schools and clubs in Blackpool, plural. And they reference to someone whose name should be anonymised, who was also their captain of the England youth squad. In the squad are Tim Ellis, son of Blackpool manager Sam Ellis and Tony Green. And then why come to New Zealand? I have taken a squad to the United States 7 or 8 times and broke that tradition by coming out to Wellington 2 years ago. I should say this is, we have a date for this, it's May 1987, I think. I found people in New Zealand were more receptive and found the boys enjoyed it more, so we came back. New Zealand's a marvellous country. On this trip, they will have 11 days holiday in Bangkok on their way home. The total cost is about $70,000. I think it was about 2 to 1 exchange rate for New Zealand dollars. 17th of June 1987, I'm told, is the date of the article. And so, again, this is, I mean, of course we accept that there's a reference to Mr. Ellis, the Blackpool manager, and there's also a reference, I think, right at the end to someone called Kenny Harlock, who was going back to the penultimate paragraph, who plays for West Auckland and returns to Blackpool for another stint. Now, we accept that Blackpool there is short for Blackpool Football Club, but the rest of it is entirely consistent with what Mr. Sharp, for example, was saying. This is a team chosen from schools and clubs in the Blackpool geographical area. And what's more, this is Roper saying this is just one of his, this is his 8th or 9th trip which he's been running at his own expense, including trips to the United States. And we'll see a bit more about those when looking at some of the evidence. And so it's not being said, well, this is now a new venture. I've now, as it were, got a joint venture with Blackpool Football Club, and although I used to run the trips, it's now a Blackpool Football Club trip. It's just another of Roper's trips, including going to the Far East. He says for a holiday. We know it was actually for other purposes as well, commercial purposes. And the only other, it's a matter of concern that in the judgment, there is no mention, I think this is right, of this newspaper article, or of the photograph, or of the fact that in the photograph they're wearing another team's kit, or of the evidence which showed that 1 or 2 at most were School of Excellence as far as the evidence was concerned, or that they were selected from the local filed coast, or that 2 of the apprentices worked at the Blackpool shop belonging to Roper. Now, the only other witness, apart from the claimant, who was actually on the trip was, he doesn't mind, Mark Bradshaw, who I think had an objection to his name being mentioned. And his witness statement is at page 98 of the supplementary bundle. Oh, this is part of it. And he was a Nova Juniors South Manchester person who went on to become an apprentice. He says something in paragraph 18 which is of interest, but I'll come back to, which was about arranging training he had with other clubs, including Manchester United, Manchester City, Tottenham, West Bromwich Albion and Bury. I'll come back to that. In paragraph 20, he describes the New Zealand trip. I went on the trip to New Zealand with Roper and a number of boys from Nova Juniors in around June. No mention of Blackpool Football Club. He says there was another trip to New Zealand he went on. 21. Roper paid for me to go on these trips. And then 22. The boys on the trip were from Nova Juniors. Would have been around 11 or 12 years old. In fact, that can't be right because we know a number of them were from the Fylde Coast. So that's it must be an inaccurate recollection because we know some of them certainly had nothing to do with Nova Juniors, including the claimant himself. But he doesn't say anything about Blackpool Football Club. And what he does say in the middle of paragraph 22, well, 3 lines down, I went on the trip to help look after the younger boys, and as the trip was in June, I did not have to take any time out of playing at Blackpool, as it was out of season. Well, if it was a Blackpool trip, he wouldn't need their permission. He would be pursuing, as an apprentice, a Blackpool, his occupation as such. And then paragraph 23, from memory, I went on 3 international trips with Roper as part of Nova Juniors. As part of Nova Juniors, emphasised. The first was to America and 2 to New Zealand, with a stop off in Thailand on the way back. Paragraph 25, once in New Zealand we would meet up for days and play matches. The purpose of the trips to Thailand was not to play football, and for the first 2 days in Thailand we would be in Bangkok, so Roper would conduct business. This could consist of visiting a manufacturer there, and Roper would give us Lacoste badges, which were the Lacoste logo of a crocodile, and Lacoste labels to be sewn into the collars of shirts. We'd have about 1,000 labels and 1,000 crocodile logos each to take back to England with us in our luggage. Roper would also bring back a massive container of sports clothing back with him from Thailand. Once in England, I believe he'd take these clothes to his warehouse in Cheetham Hill. I think that's in Stockport, or maybe inside Manchester. It's just north of the city. Of Manchester. It's just north of Manchester, I'm told. So that's Bradshaw. Intriguingly, not supporting any suggestion that this was a Blackpool Football Club School of Excellence or any other Blackpool Football Club trip. And then we have his oral evidence. He fills in some details. Transcript, page. I think I can come back to that later. Can I go to another witness who gave evidence about trips to America, who is anonymized as CFS? Now, his it's the transcript of his cross-examination, page 129. And he states, I'll be reminded. And he's at page, he's a bit older than the claimant, but page 129. He says this at letter A. He's answering a question. Yeah, well, Graham, you're talking about someone called Graham Reedy. Lived across the road, and obviously he played for Nova Juniors. So my primary school played a team from America. How did that come about? He says they were based in Anaheim, which is in California. He says that. And then he says at letter D, they're an area team in Anaheim. They're better players. He went out in 1980 to Anaheim. Yeah, 3 or 4 times I went out to America with Nova. 3 or 4 times, yeah. And then at page 131, I think this is still CFS, yeah, just to check. Top of the page, you say in paragraph 8 you went with 2 other boys. I think there were only 3 boys on the trip. No. Or those were the only ones. No, just us 3. We didn't play. We had no games over there. Oh, I see. Just to set up teams. I think we did some training with the American boys. Any other adults on the trip? No. Watched the Americans playing. And then at letter D says the Americans came to England and he played against them. In fact, that was when he was originally approached by Frank Roper. Letter F, you went with them in the summer of 1980. You were only 10 and a half, were you? Answer, yes, that was my last year in primary school. How old were 2 names mentioned who went on the trip? The same age. So you have 3 10-and-a-half-year-olds. Over the page, in America when he was there, letter A, we used to go to Tijuana on the border of Mexico and used to buy like Lacoste t-shirts in big skips and stuff. And he brought that back to England, yeah. So Anaheim is in Southern California. Did you go across the border into Mexico? Yeah. 8 or 9 of us went. We all drove. And that letter F, he confirms it was imported, all this stuff. He had a sportswear shop. He had a house that was like a warehouse at Stockport, 3-story house. He treated it as a warehouse. And then he said he lived in Stockport. This is the reference I gave earlier. He was living with, and there's a name of someone who appears in the New Zealand photograph. Mum lived in Stockport, and so Roper was living with them in Heald Green. 3 or 4 years. And the father of that boy also was a Nova Juniors coach at some point. So what we actually have is a reference to a series of trips that Roper organises. Certainly those American trips cannot be for the benefit of, it's not been suggested they were for the benefit of Blackpool Football Club. Indeed, it would be difficult to see how they could benefit any football club. He's taking 3 boys, very young boys, and he's using the opportunity to get some imported goods from Mexico, just as he was using the opportunity of this trip to New Zealand to stop off in Bangkok and bring back goods in large containers. So unless there's some reason to say that the New Zealand trip was a new departure, and it clearly wasn't because of what he told the reporter in the New Zealand Herald, this is just yet another Roper venture. And the judge doesn't anywhere mention this evidence of Bradshaw. I think there's a passing reference to bringing Kit back. He does mention in the judgment at 174 that the Roper did business with sportswear manufacturers. But he implies that was just allowing the boys to bring Lacoste labels back they could sell on their own account, as it were a perk for the boys. Otherwise, no mention of this major underlying purpose of the trip costing 20, 25, 30,000 pounds. So this is not insofar as the claim is put on the basis that this was a trip for the boys from the School of Excellence, that is simply contradicted by the evidence called on behalf of the claimant. And I haven't mentioned at this point the evidence the defendant was able to call in the absence of Mr. Chapman, who would have been the ideal person as it being in charge of youth development at the club. But William Hurst was his right-hand man. He's been described by Mr. Ellis. And his witness statement, which is at supplementary bundle, page 117, again, contradicts any suggestion this was a Blackpool trip, and this is, of course, if one needs contradiction from him, given what Mr. Ellis himself had said. In paragraph 11,
Supplementary bundle 117.
119 is the
119.
part I want. He describes the School of Excellence and what it was, paragraph 11. Didn't have a recognised team. 11 to 14-year-olds, they just trained on Tuesdays and Thursdays, occasionally school holidays. Occasionally, I should have said, occasionally the club would enter a team to play in a local competition or organise a friendly match. Not very often. And then he says in paragraph 12, all decisions as to whether a player signed were effectively made by Mr. Chapman, though Ellis and the directors would have ultimate say. I also helped, paragraph 13, Chapman with scouting duties. I was involved in scouting at Blackpool and the Fylde area in general. And paragraph 14, again, Chapman would decide whether any player continued to train and play at the School of Excellence or sign associated schoolboy forms. The decision would be made by Chapman alone. The claimant, it will be recalled, was saying, although it turned out he didn't actually have any direct knowledge of it, that he had understood that Roper had the power to select him for the School of Excellence. Then he says in paragraph, I'll come back to what he knows about Roper, but at paragraph 25 he deals with the New Zealand trip. I was aware that Mr. Roper used to arrange annual trips abroad for his Nova team and would sometimes invite other players who trained with the Blackpool School of Excellence to go on these. However, if any players did go on these trips, that was through private arrangements between Mr. Roper and the players' parents. Around the sports shop in the Manchester and Blackpool areas, they would stop off in Thailand and he would use the players to bring back large quantities of either cut-price football shirts or other items of sports kit. And then 26, I read on assertions in the press that Mr. Chapman and I were complicit in arranging these trips abroad. That is not the case. I can categorically state that I was never involved in the organising of these trips. As far as I'm aware, neither was Mr. Chapman, nor were the tours organised, funded or endorsed by the club as far as I'm aware. Would have been organised, any tour would have been organised by Mr. Chapman with the board's approval and not Mr. Roper. I only recall one such tour, which was to Italy. So that was what Mr. Hurst said. And again, this is not mentioned by the judge. Now, rather important evidence. If that is the case, we are required to meet. And again, knocks on the head any suggestion that the primary facts were not in dispute. And then I don't think I need to take you to the Mr. Hurst's oral evidence, but Mr. Johnson, the club secretary of the time, at page 127, said that paragraph 19, page 131, sorry, I do not remember the club arranging any trips abroad for these players during the period I was employed by the club, because I would undoubtedly have known about them, because they would have to be authorised by the board responsible for making any payment. In fact, I cannot even remember the possibility of such a trip being considered. Then in the next paragraph, he says, the only thing I do remember is that on one occasion the board was asked to make a one-off donation towards the cost of a trip Roper was organising for his Nova team. I cannot now remember when this was or how it came about. Small contribution in the region of £500, small percentage. Would have been documented in the club's board minutes and financial records. The trip and any other trips Roper organised for his Nova team were completely independent of the club, or in no way official Blackpool Football Club trips. Now again, that last part isn't mentioned. What is mentioned by the judge is the £500 donation. Rather oddly, the judge took against this witness, said he was partisan, which is odd because he's the one who volunteers this recollection. There were no surviving documents of a £500 donation, which one would have thought would suggest that he was doing his best to give an honest recollection. No, so that was the state of the evidence. So, my lords, what we asked rhetorically is how could the judge conclude that there could be any evidential basis for Blackpool Football Club being vicariously liable for the torts of Roper on this trip? The judge said in paragraph 175 of the judgment, perhaps I can, for this purpose, take you to it.
Can you give us the
Yes,
paragraph
core
number again?
bundle, 175, core bundle, page 116. He says, after saying it's just to hold Blackpool FC vicariously liable for his abuse on the trip. Fourth line, Blackpool FC, given its inadequate resources, was never going to be able to run this as an official trip. But it was as close to an official trip as made no difference. It was a football tour that was part of Roper's operation in building the allegiance of promising young footballers to Blackpool Football Club. He would swiftly followed it up by trying to sign them up to Blackpool FC feeder team he ran at Nova Juniors. In fact, some resisted his efforts, making no difference. The parents only allowed Roper to take their sons on this tour because they saw it as part of Blackpool FC recruitment operation, offering the boys a prospect, if they were good enough, of finding an opening at Blackpool FC in the due course, or at least benefiting in their playing as youths. There was not a scrap of evidence with respect to support that assertion. No one said that. The most one had was that Roper, with his Nova Juniors, had an existing relationship with Blackpool Football Club and had offered regularly offered good players to them. There's no suggestion. The only parents who gave evidence were Mr. Frank Sharp and Sam Ellis, the manager. No suggestion that anyone sent their boys on the tour because it was part of the Blackpool recruitment operation. On the contrary, the most you get is that Mr. Ellis was happy to send his son, and that gave that reassured them about who Roper was, which is a different matter. He's giving his that in his capacity as a parent. His son wasn't even at Blackpool Football Club. So to say it was not an official Blackpool Football Club, but as close to an official trip has made no difference, is not, with respect, an answer. It either was a Blackpool Football Club trip or it wasn't. And the suggestion that it was endorsed, well, it begs the question as to what that means. Does endorsing an activity by sending a cheque for a very small amount, is that enough to make it to bring one in some sort of relationship, which gives rise to obligations, vicarious liability obligations?
And was the evidence that from Mr. Johnson that £500 came after a request from Mr. Roper?
Yes. Yes, I think through Mr. Ellis, that's right. Of course, Mr. Ellis was sending his son there, so the suggestion was made was that it was Mr. Ellis asking in his capacity as a parent, effectively, for the Blackpool board to make a contribution. But there is that slender piece of evidence of a connection, but that's the only piece of evidence. And it's contradicted by Mr. Ellis himself, who said it wasn't a Blackpool Football Club trip. So what seems to have happened is that the learned judge approached the matter, as it were, very indirectly, because he then started to talk about Nova Juniors as being a feeder team, as he called it. Now, that was an expression some people used, but it was never defined. And really, we submit, doesn't take the matter any further, because of course it's entirely understood that these junior teams, if the coaches, if they're good, will identify good players and will have recruited them for their teams. And having recruited, will then want to offer them to clubs. And sometimes they will get a reward, a commission. no evidence Mr. Roper ever did. But to say it's a feeder team just simply begs the question about Nova Juniors. The suggestion also made, and this is in paragraph, going back a bit, 161, the judge said, 3 lines from the end of this paragraph, conversely, Nova Juniors was not an independent club. It was a Blackpool feeder club. Well, with respect, there was no evidence of that. In fact, the evidence was to the contrary. There was a witness, well, it's Bradshaw himself, who at page, in the transcript, page 103, said he'd been in with Nova Juniors for a number of years. Page 103, transcript, letter E. He'd been with Nova Juniors, this is South Manchester, for about 4 years. So letter E, I joined Blackpool in 1986, so it was 4 years before that. Letter F. During your time, where did Nova Juniors play their home games? Different places, because we went into different leagues. We played one season at Marple, it was like a park in Marple. The whole league played there, so you played there every week. Whether you were home or away, we played at ITI and Hyde for a season, and we played in a different league. There were different venues from time to time. Did they have a clubhouse? No. You know how they came to be funded? No. Just to tell what Frank Roper told us. He had a team before us where a couple of the boys were successful and went into professional football. And I should say, my name is mentioned. This is my learned junior, Mr. Futrell, who was cross-examining. And I've got some other references to make. There are other witnesses who described Nova Juniors as a regular Sunday League football team in South Manchester. There was no evidence it wasn't independent. The fact that Mr. Roper was a fan of Blackpool and may have liked to send good players there and had provided put forward some good players, in itself doesn't prove, or doesn't remotely suggest it wasn't an independent junior football team. What was clear was that there was no question of Nova Juniors being somehow exclusively dedicated to the recruitment of boys for Blackpool Football Club. The evidence was that boys went to all sorts of professional clubs if they went on to professional careers. And there's quite an interesting section of Mr. Bradshaw's cross-examination, which we see at get it. Is it 107? Question about the, yes, that's right. 107, he's being asked again by Mr. Futrell, in the middle of the page, you say, this is in paragraph 18, I think of his witness statement. You say, Roper would also sometimes drive me to other youth teams, yeah. Do you remember which teams they were? Predominantly it was Manchester United to the Cliff. How did you drive there? Drove me down there. An important answer. I've still kept all the letters that I got from United there, and I expressed concern about getting my parents. My dad was there on the day he approached us and said, you know, it would be a struggle to get to United. That was a Saturday game, and then when I mentioned it to Frank Roper, he offered to pick me up and take me. So sometimes I had to get the bus, sometimes he came and took me down. Once he was at United, he also got 2 other players to get in the training session. So he approached their coaches and said, I've got 2 other players who play for me who are good. They started training there as well. There were 3 of us in the end. And over the page, letter D made clear that this continued for some 18 months. And at the bottom of the page, he had a lot of interest with Bradshaw from other clubs, Manchester United, Tottenham, Hotspur, West Bromwich, Bury. How did you come to train with those teams? And he says, well, he was a scout at Manchester City, came and had a look at him. Someone from West Bromwich did the same. And then in the middle of the page, question, I think it's fair to say, and they've already confirmed me, you did not sign for Blackpool. You were not put under any pressure to sign for Blackpool, were you? Not pressure, just, I'd say, friendly banter. You were not dropped from Nova Juniors. No, no. And then a similar question. At page 111, top of the page, quoting from his witness statement, remember Kevin Sharp and Jamie Forrester on the trips, and they were put under some pressure to sign for Blackpool Football Club. What's the basis for that answer? Just in a similar way, not in a nasty way, in a banter way, you know. He described that sort of banter, cocooning amongst the boys. Sorry, this is a question. He's quoting Mr. Sharp. The question is, he described cocooning amongst the boys. Was does that accord with your? Does not suggest there any other other than internal pressure. Yeah, is that the same for Jamie Forrester? Yes. I need to ask you any.
Mr. West, what's cocooning?
Well, I don't know. It's a word that Mr. Sharp used, and the judge refers to that in his judgment. It's rather curious because at paragraph 159, is it? Um,
151.
oh, thank you.
Next page.
Thank you. Judgment.
Paragraph 151.
Yes, this is Sharp's evidence being quoted, paragraph 151, and then the judge picks it up, or makes a conclusion, I think, about 159. Somewhere, someone will prompt me that there is a reference to this, or there's a paraphrase of this.
Closed environment 159.
Oh, that's it. Yes, it is the yes, that's it. It's judgment in 159. It's his conclusion on stage 1 by vicarious liability. Roper was a Blackpool scout, and his Nova Juniors side was a Blackpool feeder team. Its sole purpose was to take boys, so far as possible, into a closed environment in which Blackpool had a better chance than any other club of securing their signatures when they were old enough to sign, if not before. Some evidence some boys did not take bait. DSN himself did not. Roper was very effective. Well, if it's Mr. Sharp, he didn't have anything to do with Nova Juniors South Manchester. His son did not join. I think the later team, which was set up, called Nova in Blackpool after the New Zealand trip. And so that really doesn't help. Other than that, there was nothing to show other than, and we entirely accept this, that Roper was a Blackpool Football Club fan. He was known there. He had sent some successful players to Blackpool. And to that extent, Nova Juniors was one of a number of junior teams that could be said to have provided a useful source of raw material, as it were, for the club. Mr. Ellis, I think, said that they had scouts all over the country. He was just one of them. And so of the 11 witnesses, the judge, well, we say this in paragraph 58 of the skeleton, the 11 witnesses called, including the claimant, who gave evidence about their experiences with the Blackpool Football Club. 5 never joined Blackpool Football Club in any capacity. This is paragraph 58 of our skeleton. And of the 6 who did, 2 were introduced by other scouts. One was approached via his parents by Chapman directly, and one didn't say how he was originally spotted. And that left Bradshaw himself, and I've already explained that his evidence was that he was trying out other clubs. He was being pursued by other clubs, well-known clubs, and Roper was quite happy to drive him and suggested a couple of other boys from Nova Juniors. Michael Davis gave evidence. He was brought to the club by a scout called Tommy Pendlebury, and JKL, whose evidence was read because he was ill. He was scouted by someone called Graham Davis. No doubt there were many such scouts from around the place, school sports teachers, junior club coaches, and so on. But what is clear is that there was no exclusive arrangement. Mr. Ellis's witness statement, which we've had a look at, but in a different context, at page 111, supplementary Bible. Said at paragraph 6, he wasn't really involved with the youth setup. He left that to Jack Chapman, who was very good at his job. Jack had wide range of contacts with the game, including Frank Roper, who was very closely associated with in terms of producing youth players for the club. 7. As far as I was aware, Nova was a feeder team solely for Blackpool FC. Solely for. But we've just seen that that can't fit in with Mr. Bradshaw's evidence. And Roper did not introduce players into other clubs within the northwest or further afield. This is Mr. Ellis, who says as far as he was aware, and he wasn't really involved with this side. And then paragraph 9, as far as I am concerned, Frank Roper was a scout for the Manchester area for Blackpool Football Club and the coach of an affiliated feeder team. And he brought players to the club. He was basically given the freedom of the place. He would bring players during school holidays and weekends. Understood there were training sessions. But I wasn't involved in those sessions. Chapman was. Paragraph 12, also, sorry, I've read that. That was the New Zealand trip. And then paragraph 13, I don't know if he received any remuneration from the club. I wasn't involved in that side of things. I generally left Jack to his own devices with running the youth side of the club. That was his evidence, which was, again, a recollection over 30 years later of matters for which he had no direct involvement, but Mr. Chapman would have done. And in his evidence, he said this, transcript page 158. Letter F, and the judge refers at one point in the judgment to the club lavishing things on Mr. Roper, but in fact it refers to tickets being given to boys. But at letter F he says, 158, having agreed that attendance in those days was generally not that great. People were not fighting to get tickets. No, to be frank, couldn't give them away. So not such a lavish thing. And then at paragraph 159, this is a limitation point really, he says, Bill Hurst, letter C, he was in effect Jack's assistant, and he agrees he would call him Jack's right-hand man. Jack had a good reputation, without a doubt. Took him to another club to bury him. And then in page 161, just above letter C, how much personal knowledge did you have in your time at Blackpool with Nova Juniors? Jack would tell me when the players were coming in the school holidays and which ones of them were playing on the Saturday for the youth team, right? I didn't get much time to watch them, no. You don't have many staff when you're bottom of the 4th division, you know. You have to do most things yourself, right? So I left it to Jack, he was very confident. And then he's asked, you use the expression affiliated feeder team. Do you mean anything in particular by it? No, I just mean that it seemed that Frank enjoyed coming to Blackpool, enjoyed the aura around the club that he had, and the youth system was dependent on his involvement. but not exclusively dependent. No, not exclusively, but it was dependent to a large extent because the local players we had were good. The ones Frank brought in were better. Well, he brought in two, it says starts, it means stars, should be stars, and the reference to two names, well-known players. Went on to play for England. And page 162, letter D, he says he was very rarely in Frank Roper's company. Never went out with him, socialising with him. Never came, didn't remember him coming to his office. Roper had no access to the first team dressing room. Was he involved in coaching at the club? No, no. And Mr. Chapman is obviously the man who would decide whether to sign a youth player. Yes, full authority. I think I've read that part. So there isn't really any evidence of some exclusive arrangement. Mr. Chadwick, who was the chairman at the relevant time, in his witness statement, which is it? Page, the supplementary bundle, page 114, he simply says at page 115, paragraph 9, I certainly remember the name Frank Roper from my time at the club, although I do not recall him ever being discussed at any board meetings. He used to refer to the players to the club on occasions via Jack Chapman, who was in charge of youth setup. He recalled his name because he referred Paul Stewart and David Barnsley. And William Hurst, page 118, paragraph 4, he worked as a part-time youth scouting physio coach, had duties at the club. He worked very closely with Mr. Chapman at paragraph 6. And paragraph 18, I recall Mr. Roper. His involvement was limited to the Sunday League football team he called Nova Juniors. As far as I'm aware, based in Stockport, 60 miles away. I recall Mr. Roper occasionally referred players from his Nova team. Paragraph 20, I understand the claimant alleges you had to play for Nova in order to play for the club's School of Excellence. This is not correct. Players in the youth setup played for lots of different teams. It refers to the Boundary Boys in Oldham. As far as I'm aware, Mr. Roper was never employed by the club, even in a voluntary capacity. 22, he was rarely at the School of Excellence. Training sessions took no part in the coaching. He would often stay to play when he brought his Nova players to and from training. So we have evidence which simply does not support any suggestion that Nova Juniors was not in itself an independent entity, a junior football club, Sunday League club based in South Manchester. That it was the source of good players is nothing to the point. That doesn't prevent it being independent.
In paragraph 19, which you've just taken us to, 3 lines from the end, where he says the club's youth team did have a minibus. What's the youth team he's referring to there?
Is this 19 of Mr. Hurt?
Page 122.
Oh, thank you.
Paragraph 19. 3 lines from the end. The club's youth team. Which team is
yes,
that?
there is an A team, which was the associated school boys were 14 upwards.
So that's the 14 upwards.
Well, I'm not sure whether he's referring to that or the apprentices who were the A team.
Okay, but he's certainly not referring to the BSc.
No, no.
What I call BSc.
Some associated school boys could play in the A team if they were good enough and towards the end of their...
Yes, the best associated school boys were sometimes allowed to play in the A team, which was the youth team, but not School of Excellence, which I say it wasn't a school, it's just really a place where boys could go and get some experience of training. And so this doesn't, so the evidence simply doesn't support an approach that this was somehow Nova Juniors was, if this is what the judge is saying, we're not entirely clear, saying it wasn't an independent club, and talking about cocooning, that somehow this was an outpost or an outreach of Blackpool Football Club. We have evidence that a number of boys, as I've already said, a number of boys from Nova Juniors did not go to Blackpool Football Club, but went to other clubs, well-known clubs. And we know a number of boys on this New Zealand trip didn't go to Blackpool Football Club. So even if one approaches the matter indirectly by saying, well, perhaps not an official Blackpool Football Club trip, but a Roper trip, but endorsed in some way, and somehow Roper then is integrated in the business because he's running and not a team which isn't independent. That evidence, there is no evidence to support that. The evidence is to the contrary. And my lady and my lords, I'm getting close to finishing my references to the evidence. It's been rather long-winded, I acknowledge, but there are, as I've said, significant omissions in the judgment in relation to aspects of this evidence.
Will you finish this part of your
Yes,
submission before the short adjournment?
I will. I was going to come fairly quickly on to the authorities on vicarious liability. What I was proposing to do was slightly the wrong way around, but unless I address the court first on vicarious liability, the limitation prejudice issue isn't put into the right context.
Yes, we understood that. I'm just trying to get an understanding of where we are in the course of your submissions overall.
Well, I'm conscious my learned friend must have time. I imagine the court wants to rise midday tomorrow. Would that be correct, or do we have the whole?
I think you've certainly got the morning.
Yeah, right. Well, I think we can aim for lunchtime, as it were, and that will leave my learned friend. But I will be a bit of time on the authorities.
Yes, of course.
Thank you.
I wasn't seeking to rush you
thank
at
you.
all, Mr. Wesley.
Thank you very much, lady. And I think that maybe I'll be prompted otherwise, possibly. I think somewhere there is evidence. I would like to be reminded where it is. That I think Mr. Ellis said there was he had scouts all over the country.
I think you've already referred.
Oh, I have. I didn't. I may have done that. There is one other aspect of the amended particulars of claim, which needs to be noticed. I think I've already taken the court to it. But at core bundle, page 129, and as I've said, the focus of the particulars of claim is on Roper being a scout and Roper taking boys from the School of Excellence on the trip. And then at page 129, paragraph 15.2, it's this third line, 15.2, that the defendant caused or permitted Mr. Roper to hold himself out as being a representative of the defendant club and derive benefit from that relationship by using Mr. Roper as a source of young footballing talent. Now, we submit that there is no and never was any evidence that anything was said by the club as opposed to Roper himself as to his influence with the club, his relationship with it, and what he could do for boys who might want to go on to a professional career. And that's an essential point. It can never be fair, just and reasonable to impose liability on someone who is, as it were, dropped in it by the tortfeasor without saying anything to the effect that that person is representing me.
You've actually made that submission.
I have made. I'm sorry, my lady.
No. I'm just
Thank you.
concerned if you're overheating, as it were.
Yes, I am a bit. But it's worth coming back to that, having looked at the evidence, that it doesn't really say that and say it's all about what Roper himself was saying. And of course, using him as a source of footballing talent may well be right. We have no objection to that. But clubs, like any other business or enterprise, uses all sorts of suppliers, organisations, independent contractors, volunteers, they may be fans, they may be people who supply services at a cost, and may be reliant upon them, but that doesn't make them a quasi-employee, which is what vicarious liability is concerned with. So, what I will come to is, I hope, a relatively brief survey of the authorities on vicarious liability. We do set it out in the skeleton argument, but I wonder if I could draw attention to one or two useful passages. And the vicarious liability volume starts at tab 13 of the authorities. I'll try and do it in two separate sections. As the court knows, there is vicarious liability stage 1, the relationship, and there's vicarious liability stage 2, is the tort closely connected. Both of them, of course, addressed after this judgment by the Supreme Court in Barclays Bank and Morrison's, the second Morrison's case. But I'll start with the Christian Brothers case, which is at tab 16. We call it Christian Brothers, I'm not quite sure why, but it was the case of it was actually an approved school, as they used to be known, a children's home, effectively for delinquents, as they used to be known, probably not anymore, which was run in part by a Catholic diocese and staffed in part by lay brothers who belonged to the De La Salle Institute and were bound by vows of poverty and so on, and therefore there was no direct contract of employment. So the issue was whether there was potential liability for serious abuse carried out by one of them, who I think was the headmaster, and other teachers. Lord Phillips, I think, gives the sole, the main judgment, I think it may give the sole. So, thank you. He does, and this is starting at page, I haven't got the pagination, but if I could take the court first of all to paragraph 17, which is under the heading Control. The undertaking by each brother to go wherever he might be sent meant that the Institute controlled where it was the brothers taught. The Institute could not, of course, control whether schools owned by third parties engaged brothers as teachers. It could, however, control whether a brother worked in a school that was prepared to engage in. Because the managers of St. William's were always keen to have a brother as headmaster of the school, the Institute, in effect, determined who the headmaster of the school would be. And there's further detail. Paragraph 18, it is an agreed fact that if a brother was sent to a school managed by a third party, the Institute's control over the life remained complete. So those were the underlying facts, and the focus on control will be important in my submissions a bit later. Then in paragraph 21, there is the familiar two-stage test, which was confirmed in this case. And paragraph 47, sorry, paragraph 35 is the well-known part where Lord Phillips discusses the policy reasons why, in the employer-employee relationship, vicarious liability will be imposed under 5 topics. The first is probably not relevant, but 2, the tort will have been committed as a result of activity being taken by the employee on behalf of the employer. 3, the employee's activity is likely to be part of the business activity of the employer. And 4, the employer, by employing the employee to carry out the activity, will have created the risk of the tort committed by the employee. 5, the employee will, to a greater or lesser degree, have been under the control of the employer. And then he has a section starting the significance of control. And what has been, we submit, misunderstood in some of these cases is that there's a passing remark, I think we'll see it later, that the control is not such a significant factor. But all that is meant is that there is a recognition that in many activities, control must be limited. The airline board of directors doesn't tell a pilot how to land his aircraft, but does tell him where to take his aircraft, for example. And hospital authorities don't tell surgeons how to perform operations, but do tell them to perform an operation. And so it's not that the control is not important. It's that the control needs to be understood as meaning not necessarily a detailed control of every aspect of the employee's work, but there must be some element of control. And that's made clear at the end of paragraph 36, where Lord Phillips says many employees apply a skill or expertise that is not susceptible to direction by anyone else in the company that employs them. Thus, the significance of control today is the employer can direct what the employee does, not how he does it. So it is significant. And just pausing there, we ask rhetorically, well, what control, on the evidence before the judge, did Blackpool Football Club have over Roper? Oddly enough, the judge at one point said that Roper seemed to be controlling Chapman rather than the other way around. I'm quite sure why that was, but the reality was that Roper was a completely free agent. And that's what makes him equivalent to an independent contractor. He chose to send refer boys to Blackpool. He didn't have to. He could send them elsewhere. There was no direction given to him. The judge seems to think, well, he's a volunteer. He's like Mr. Hurst, who was also a volunteer. In fact, Mr. Hurst had set duties, as volunteers often do. He turned up twice he had a job as an ambulance man, but in the evenings, twice a week, he turned up. He was a physiotherapist. He was paid expenses to go scouting, to go to watch matches. He had a regular job in all but name. He didn't have a contract of employment because he was a volunteer. That's completely different from Mr. Roper, who is entirely free, and always was, to do exactly what he wanted. We say it can never be fair, just and reasonable to impose liability on a party who has no control over the wrongdoer. And then at paragraph 47, Lord Phillips says, I've identified those incidents of the relationship between employee that make it fair, just and reasonable. Where the defendant and the tortfeasor are not bound by a contract of employment, but their relationship has the same incidents, that relationship can properly give rise to vicarious liability on the ground that it is akin to that between an employer and an employee. And that's where that's been stretched to breaking point. But Lady Hale in Barclays has restored the balance to allow cases in which there's nothing remotely equivalent in the case to the full-time employee. Lord Phillips is talking about someone, and we know from the facts of this case, someone who is, for all intents and purposes, on the staff, part of the workforce, only for technical reasons, is not employed. That, of course, was the ratio in that case, that those staff were sufficiently under the control of the Institute, and were therefore, and were in effect quasi-employees. I'll come back to references in that judgment to the Stage 2 issue, and can go to the next one is Cox and Ministry of Justice at tab 17. And this is a different case, a fairly conventional personal injury case, and the question was whether a prisoner who's given certain tasks to do in the prison kitchen drops a bag of rice on the claimant's back, injuring her, is going to impose liability on the Ministry of Justice. One would have thought the answer would be fairly obvious, but Lord Reed, giving, I think, again, the sole judgment, with whom the others agree, reviews the issue. And paragraph 21, Lord Reed says the fifth of the factors, those are the 5 factors in Lord Phillips's paragraph 35 in the St William's case. That the tortfeasor will, to a greater or lesser degree, have been under the control of the defendant, no longer has the significance that it was sometimes considered to have in the past, as Lord Phillips immediately made clear. As he explained in paragraph 36, the ability to direct how an individual did his work was sometimes regarded as an important test. Not realistic in modern life to look for a right to direct how an employee should perform his duties as a necessary element. Nor indeed was it in times gone by. If one thinks of the degree of, the degree of control which an owner of a ship could have exercised over the master while the ship was at sea. Accordingly, as Lord Phillips stated, the significance of control is that the defendant can direct what the tortfeasor does, not how he does it. So understood, it is a factor which is unlikely to be of independent significance in most cases. On the other hand, the absence of even that vestigial degree of control will be liable to negative the imposition of vicarious liability. So control is still required, and how could it be otherwise if it's going to be fair, just and reasonable to impose liability? But it may be a hands-off sort of control. But we don't even have that in this case. Nothing to suggest that, apart from the lavishing gifts on Mr. Roper, that he was required, or could have been required, to do anything on a particular day for the club. And paragraph 24, he just pick up the last words, reciting what Lord Phillips said in the Christian Brothers case, talking about where the commission of the wrongful act is a risk created by the defendant by assigning those activities to the individual in question. And I'm going to come back to that in relation to stage 2, but if it isn't an official Blackpool Football Club trip, in other words, if Mr. Roper is not, as it were, the representative of the club on the trip, but he's merely a scout, then in what sense has any risk been created by, even if he was appointed as a scout, even if he was paid as a scout, and he was on the payroll, in what sense has the risk of him abusing the claimant been created by that relationship?
Well, the answer to that question, whether it's right or wrong, is that if, which was the view the judge took, if Blackpool are using their scouts to do work which, were they richer, they would be doing themselves and doing more formally. If you engage scouts to go out and do your work, you increase the what's in some places called the enterprise risk.
Well, you don't. What you don't do. We're just talking about scouting, going to watch matches, or referring players. That doesn't increase any risk. When I think I need to come back to this on stage 2. But the authorities, particularly those concerned with sexual abuse, are focusing on a close relationship which carries with it increased risk if, all unknown to the employer, there's an intimate relationship or a vulnerable relationship. That's why we accept if it's an official Blackpool Club trip to New Zealand, Mr. Roper is, as it were, in loco parentis.
Well, I accept that you have to perform a detailed analysis of the relationship.
Yes.
But if it is justified to conclude that as an integral part of Blackpool's business, they have a relationship with Roper which involves him going out to find vulnerable young boys, which is what they are, then there is a degree of risk associated with that, in the same way as there is always a degree of risk associated with putting people to work in residential schools.
Well,
it's different. But
it is different. And, of course, the key point here is that apart from Claimant being at the School of Excellence, which we say is entirely incidental, and, of course, most of the boys on the trip weren't, these were... Blackpool wasn't in loco parentis. This wasn't a residential school where they are sending out boys to whom they owe a duty anyway. It's the parents who are handing their boys over to Mr. Roper. That's the true analysis. But I will come back to that because there are some dicta which may assist on it. But we say that scouting, which is after all simply, if it's conventional scouting, which is you watch a match, you're in a public place, you're watching a match, or identifying a boy. This isn't sort of activity which necessarily involves people boarding in a boarding house or staying with somebody, or again leaving aside the trip to New Zealand.
But up to a point. But it's surely well known and in the public domain that one of the problems with paedophile scouts has been that they have taken advantage of the occasions when they take the child to a match or coming back from a match or whatever.
Oh yes.
So, depending upon the nature of the activity and the closeness of the relationship with Blackpool, it is not implausible to find that engaging a scout may increase or form part of the enterprise risk.
Well, my lord, can I say, for these purposes, it's sufficient to say that does require a very close understanding of what his functions were that gave rise to the stage one.
That's why you tried to hit that first with your review of the evidence.
Exactly. Yeah. My lady, my lords, I think it's paragraph 29 in Cox has some importance because of the suggestion that there's somehow a different rule in sexual abuse cases. Lord Reid says, it is important, however, to understand that the general approach which Lord Phillips described is not confined to some special category of cases such as sexual abuse of children. It is intended to provide a basis for identifying the circumstances in which vicarious liability may in principle be imposed outside relationships of employment. By focusing on the business activities carried on by the defendant and their attendant risks, it directs attention to the issues which are likely to be relevant in the context of modern workplaces, where workers may in reality be part of the workforce of an organisation without having a contracting employment with it. Also reflects prevailing ideas about the responsibility of businesses for the risks which are created by their activities, results in an extension of the scope of vicarious liability beyond the responsibility of an employer for the acts and omissions of the employees, course of the employment, but not to the extent of imposing such liability where a tortfeasor's activities are entirely attributable to the conduct of a recognisably independent business of his own or of a third party. And that's picked up by Lady Hale in the Barclays case, which we'll come to. And then in paragraph 30, after saying one shouldn't be misled by a narrow focus on semantics, says it just above letter H, the individual for whose conduct it may be vicariously liable must carry on activities assigned to him by the defendant as an integral part of the operation and for its benefit. The defendant must, by assigning those activities to him, have created a risk of his committing the tort. So we're coming back to the point we've just been discussing. So there's a requirement to see, well, what's been assigned and how does that... For example, to take an absurd example, let's say you say to a scout, watch videos of matches. There couldn't be any risk attached to that. There's going to be no contact at all. That wouldn't be creating a risk. If you send a scout, say to a scout, go to a local match, is there any risk if he's just standing on the touchline and watching? Or it may be something more intimate, as it were. But one needs to understand much more about what is required. Again, it's what the employer, in quotes, is requiring him to do. And then Barclays itself, on stage one, which is at tab 19. Of course, this is a sex abuse case, and it's a case where the doctor was carrying out medical examinations for the bank, for recruits and took the opportunity to abuse them. There would have been no issue about stage 2. Clearly, it was closely connected to what he was required to do, which was to examine the patients. But there was a real issue about stage 1, because the Supreme Court said he was an independent contractor. And the law hasn't moved so far as to allow to say that exception has gone. Lady Hale, again, I think, giving the sole judgment. Yes, says at paragraph 15, well, these are very long sections. I don't want to just stand here reading them, but can I just pick out highlights from what she says? Quoting Lord Phillips, paragraph 35, we've seen that. Quoting Lord Hobhouse in Lister and Hesley Hall, these are policy reasons, not the same as defining the criteria for his application. Quoting Lord Justice Ward in E's case, coherent development of the law should proceed incrementally in a principled way. And then at the top of page 984, there appears to have been a tendency to elide the policy reasons for the doctrine of the employer's liability for the acts of his employee set out in the Christian Brothers, with the principles which would guide the development of that liability into relationships which are not employment, which are sufficiently akin to employment to make it fair, just to impose liability. Quotes from Lord Phillips, paragraph 47, the same incidents. 18, I do not believe that by his reference to those incidents, Lord Phillips is saying they were the only criteria by which to judge the question. It refers to Lord Justice Ward again. And it says, I think this is Lord Justice Ward, he had conducted a searching inquiry into whether the relationship between the priest and the bishop was more akin to employment than anything else. Again, searching inquiry is important to our limitation point. Secondly, when it came to applying the akin to employment test, Lord Phillips did not address himself to those 5 incidents, but to the detailed features of the relationship. Again, a limitation issue. Then quotes Lord Phillips, paragraph 57, identifying the features which were relevant. Under 4 heads. Oh, I think 6 altogether. And then there's a reference to Woodland and Swimming Teachers Association. That was the non-delegable duty case. And Lord Sumption saying, referring to the Christian Brothers case, and the extension to those who are not employees, but it has never extended to the negligence of those who are truly independent contractors, such as Mrs. Stopford. Lady Hale goes on, Lord Sumption not only saw the Christian Brothers case as adopting the sufficiently analogous to employment test, but also as casting no doubt on the conventional distinction between employees and those analogous to employees and independent contractors. She refers to Cox and Ministry of Justice, refers to even this, in the middle of the page, even this vestigial degree of control would point against liability. And paragraph 24, there is nothing, therefore, in the trilogy of Supreme Court cases discussed above to suggest that the classic distinction between employment and relationships akin or analogous to employment on the one hand and the relationship with an independent contractor on the other hand has been eroded. Refers to 2 cases which reached the same conclusion in this court. Lord Justice Singh and 1 case there, and a decision of the Singapore Court of Appeal, which it appears Lady Hale approves of, where page 987, letter C, the essential contribution was to fine-tune the existing framework underlying the doctrine so as to accommodate a more diverse range of relationships which might be encountered in today's context. These relationships, when whittled down to their essence, possess the same fundamental qualities as those which inhere in employer-employee relationships, and thus make it appropriate for vicarious liability to be imposed. And then we do not see how vicarious liability, the normative foundation of which rests on the theory that it is fair, just, and reasonable to hold a defendant liable for the acts of the tortfeasor, on the ground that the tortfeasor is in fact engaged in the defendant's enterprise, could possibly be extended to tortious acts committed by an independent contractor, who by definition is engaged in his own enterprise. simply nothing fair, just and reasonable about imposing secondary liability in such a situation. Then Lady Helgate's on the question, therefore, is as it has always been, whether the tortfeasor is carrying on business on his own account or in a relationship akin to employment. In doubtful cases, the 5 incidents may be helpful. And then she, further down, although they were enunciated in the context of non-commercial enterprises, they may be relevant in deciding whether workers who may be technically self-employed or agency workers are effectively part and parcel of the employer's business. But the key, as it was in Christian Brothers and Cox and Arms, will usually lie in understanding the details of the relationship. So applying that approach, Mr. Roper's Nova Junior's team, at most, is akin to an independent contractor. He's not a contractor as such, because there's no evidence he received any remuneration for introducing good players. But let's assume he had. If the arrangement was one whereby he had earned a commission on a player being signed, or on a player being sold on to another club.
You would say no obligation and no payment.
Well, no, not just that. There might be an obligation, depending on what the contract said. But
as between Roper and Blackpool.
Well, it depends. There might be a unilateral. The club might hold itself out as saying, if you produce a player, we'll pay you, a good player, and we sign him, we'll pay you commission, which I think is called a unilateral contract. Is it the Carbolic case, I think?
There's no evidence for that, is
there? No, exactly. But the point I make is a forensic one. If there had been such a contract, he would still have been an independent contractor. So it can't be. He can't cease to be in that category because he's doing it as a volunteer. Just as a fan of the club may come and help out entirely voluntarily, just as a supplier of kit to the club may give free kit, perhaps for a bit of publicity. Let's say Mr. Roper from his Blackpool shop had said to the directors of Blackpool Football Club, I can provide you with some cheap kit if you put my name on your programmes. He's still an independent contractor. He's independent. He's running a recognisably independent operation of his own. And Mr. Roper, in 2 respects, was running an independent operation. 1, Nova Juniors, South Manchester, and 2, his trip to New Zealand. And at most, the club comes in as a potential beneficiary if he chooses to continue sending good players in their direction. So that is, I think, all I need to say about stage 1. That would bring me to stage 2, possibly at 2 o'clock.
It's very good time. So, Mr. West, can you give us some idea of your programme this afternoon?
Yes.
Will we get to Mr. Counsel?
Yes, I'll make sure you do, because what I want to do is go through some further references to the judgment. Limitation, it's almost all there in our skeleton argument,
Yes.
in fact. It's putting that, it's applying the principles, which, to be fair, the judge does set out in his section on limitation, to the evidence and the issues that arise. And so I would have thought I won't be more than an hour and a half, if that's going to be all right for my own friend.
So 3:30.
Thank you.
All right. So we'll go on to the authorities in stage 2
Yes.
this afternoon. All right. Very much.
All right. So I'll end the live stream for the short adjournment. 9-second delay.